Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Let's get to a quick preview of the docket. First, what Chad Daybell needs to say to get his continuance. Debbie Collier, some new footage. Sherri Papini, once the California supermom, well, really she's just a liar, and we can prove it. Darrel Brooks' trial has already escalated into a three-ring circus, and it's only day one of jury selection. Is your handyman a serial killer? Well, one goes on trial down in Dallas. Examples of a dating malpractice, and then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. Thanks for watching. My name is Scott Reich. This is Crime Talk. We're hoping you're having a great day, not just a good day. Now, you know the drill before we get started. Subscribe if you haven't, like if you do, hit that bell for notifications, and as always, leave me a comment below. And remember, you can listen to any of our Crime Talk podcasts by simply searching us on any of your podcasting apps. Just type in Crime Talk with Scott Reich, and there we are. Anytime, anywhere you want us. All right, let's go ahead and get to the docket for October 3rd of 2022. Well, we all know that Chad Daybell's attorney, a guy by the name of John Pryor, filed a motion for a continuance. And he basically said a lot of the things that basically I've been saying that should have been going on for the last 16 months since the indictment came down, and even the year before that when these charges were actually filed as it related to specifically the abandonment of children. Anyway, John Pryor has filed this motion, and it's basically saying that he has just been too busy. And wait till you get to the language here. All right, now let's first talk about the law. Now, when a defense attorney asks on behalf of his client, the defendant, to continue a jury trial, it implicates a lot of matters. First, speedy trial. Obviously, in Idaho, it's a 6-month speedy trial date from the date that the defendant says not guilty. However, you can waive that speedy trial date, and usually a 6-month period begins along those lines. You can also toll it, which means you're going to waive it, and we're going to toll it from beginning again for, let's say, another 90 days so that you can have more time to prepare. Well, this case has been going on, and we know that it's set for trial to begin in January of 2023. Well, is that going to happen? Well, let's take a look what the legal standard is. So while determining whether in any case a continuance should be granted, that normally rests within the sole discretion of the trial court, but that discretion may not be exercised in such a manner as to deprive the defendant a reasonable opportunity to prepare his defense. And although a judge's goal of expediting the adjudication of cases, though laudable, should not blind a judge to a fault that he cannot be doubted that the right to counsel guaranteed by both the federal and state constitutions. Now, although there's plenty of case law out there about a judge's goal of expediting the adjudication of cases, and I assure you, judges keep track of how old cases are getting. Why do they do that? Well, usually the Supreme Court, state court administrator keeps track of all the cases, how long they take to resolve, and basically the judges are evaluated sometimes, or it goes up into consideration of how effectively and efficiently they move cases through. But just because that's a laudable goal, they cannot basically override their efficiency measures if it is going to override one's Sixth Amendment right to counsel. And that right to counsel effectively throws in the right to effective assistance of counsel. And there's sufficient case law out there that stands for the fundamental principle that a fundamental part of the constitutional right of an accused to be represented by counsel is that his attorney is obviously entitled to the aid of expert assistance, and he may need that in preparing a defense. An accused also has a constitutional right to put on a defense, and an accused has the right to present exculpatory evidence. Courts have reversed several convictions for failing to allow the defendant to put on a defense, and they've also found that cases need to be reversed if the defense counsel did not provide effective assistance of counsel. Now, a lot of that required language is in the motion. Let's go through the exact language of the motion, which is probably going to get a continuance in this particular case. And I'm referring specifically to the motion to continue filed by Mr. Pryor. Specifically, Mr. Pryor states, since the indictment on capital murder charges approximately 16 months ago, counsel's time has been dominated by litigating numerous issues with the indictment process, discovery, the legal authority of prosecutors in this case, and a host of other matters, as well as reviewing voluminous discovery in a case that the prosecution has repeatedly referred to as particularly complex due to conspiracy charges, the fact there are 2 co-defendants and others alleged co-conspirators, and that investigation is occurring across jurisdictions for multiple alleged homicides, which are alleged to have occurred months apart. Undersigned counsel has been handling this extremely complex case alone until this point and is currently seeking qualified co-counsel in accordance with the ABA guidelines for capital defense, as well as the practical necessity of having more than one lawyer in a case this complex. At the current time, we have been unable to secure co-counsel if and when co-counsel is hired. That attorney will require sufficient time to become well acquainted with the entire case to ensure decisions are informed and made strategically in accordance with the professional norms for capital cases. And he cites the United States Supreme Court case of Strickland, which lays out the requirements for effective assistance to counsel. Thus, co-counsel will require time to independently review all of the discovery and get up to date on the defense investigation and all of the litigation completed to date. Counsel will thereafter need sufficient time to consider and analyze legal issues and strategies, and ultimately will require time to litigate issues that arise out of this process. A qualified attorney could not possibly complete the required work in only 4 remaining months before a January 23rd trial date. Additionally, the investigation into the merits phase remains ongoing. The prosecution has recently made a request for additional DNA testing, and several discovery items still have not been turned over to the defense. Though the prosecution has no less than 5 attorneys working on this case, 5 times the manpower of undersigned counsel, they have not yet complied with their discovery obligations. Defense counsel is entitled to, and indeed required by the ABA guidelines, to independently examine, with the assistance of qualified experts, every piece of evidence the state intends to use at trial. Thus, the state's delay hinders counsel's ability to complete the necessary investigation prior to the current trial date. The pretrial litigation necessary in this case is also far from complete. Death penalty cases typically require hundreds of pretrial motions, and undersigned counsel has not yet had time to research and litigate issues that are unique to the death penalty due to the ongoing focus of evidentiary issues and other issues specific to the prosecution of this case. As discussed above, it is a fundamental duty of trial counsel to preserve all possible legal issues, particularly the ones that bear on legality of appropriateness of a sentence of death, necessitating the time and opportunity to do so. Finally, a continuance is necessary because the mitigation investigation cannot possibly be completed in 5 months. As detailed above, the mitigation investigation includes gathering numerous records generated about the client during the course of his life, in addition to the records of family members. Capital mitigation investigation generally results in thousands of pages of records. The investigation also requires interviewing immediate and extended family, friends, neighbors, teachers, church personnel, employers, colleagues, classmates, girlfriends, social services, and others who have known the client during his life. This is time-consuming and expensive, but it is mandatory in light of the prosecution's choice to continue to seek the death penalty. In the event the prosecution chooses not to seek the death penalty in this case, counsel could likely proceed to trial in early 2023. Now, ladies and gentlemen, I have told you this in the past. I have only done one death penalty case. It started out as a death penalty case, and then they decided not to seek death penalty because we presented mitigation. That was one of the first things we did in that case because we wanted to jump on the matter quickly. Now, it's been 16 months since the indictment in this particular case, and it was almost another year before that when charges were actually filed against Vallow and Daybell. Now, I get it. Chad Daybell hired John Pryor, who is a sole practitioner. But a sole practitioner cannot do this case alone. I've mentioned this before. It's very unusual. Of course, we couldn't tell for sure because the court blocks all the motions, but I was very surprised by the lack of number of motions that had been filed, at least that we can tell, up to this point, because usually they challenge the death penalty, the constitutionality of it. They filed the motions like Lori Vallow's attorneys filed the other day, basically saying you got to do away with the whole death penalty selection process. Those are types of things that are litigated on a routine basis. An experienced death penalty attorney would probably know that. He would also have a resource, a database to go through to do that. It would appear as though, according to the statements made by an officer of the court, to the court saying basically, hey, Judge, I just really haven't had time. And oh, by the way, now here we are 16 months into this. I probably better find a qualified death penalty co-counsel. But we haven't been able to do that. Attorneys are expensive. Most people cannot afford a private death penalty attorney. Why? Because, first of all, it's an expensive endeavor because the attorney is going to be working on it non-stop. And it's going to be a team of attorneys. Most death penalty teams usually consist of 2 attorneys and when I mean attorneys, 2 trial attorneys. There's usually an appellate attorney on there as well to basically file motions, set the trap for any appellate issues, an investigator, a mitigation expert, if social workers. It is usually a team of between 5 and 10 people on a death penalty case. And they're working on it literally full time. Nobody can afford that type of situation unless you are independently wealthy. All right. So it seemed to make sense that maybe the way to get a continuance here for Chad Daybell is for Mr. Pryor to withdraw and ask that court-appointed counsel proceed in his place. There's simply no way that this is going to happen. Now, I also see the effort by Mr. Pryor to basically say, hey, you take death off the table, we can go to trial, no problem, we got this handled, right? But he's got to meet his mitigation requirements under the Sixth Amendment, under death penalty litigation, to investigate family and kids and medical records. And who knows to come up with what? Who's paying for this? There's no way. I mean, maybe they're independently wealthy, but I would find it hard to believe that Chad Daybell's family could afford to pay not 1, but 2, plus experts and investigators to do this matter. It would seem as though maybe now is the time for the counsel for Mr. Daybell to say, you know what, you'd be in better hands if you got the public defender or court-appointed counsel to litigate this, and it buys you a continuance as well. Oh, and he also notes that there's DNA evidence that was basically recently requested. First, you got, why is the prosecutor just doing that now? And yes, the defense has to consult with a DNA expert regarding this process to fulfill his ethical obligations as well, particularly because it's a death penalty case. We've mentioned this before. You get super due process in a death penalty case. So what does this really mean for the hearing on October 13th when this should come up? Well, if the state is going to persist in their demand that if convicted, Lori Vallow and Chad Daybell should get the death penalty, it would seem as though Chad Daybell is going to get his continuance. Laid out all the groundwork, and the judge has to make sure that basically the defendant is receiving effective assistance of counsel. And Mr. Pryor has all but stated, Judge, I'm not effective at this point. I will be ineffective in the future, so you have to give me a continuance. We shall see what, actually, we won't be able to see it since the judge denied cameras. We will hear what takes place on October 13th. Maybe the judge won't change his mind on that one as well. We'll let you know. Next on the docket, more video released in the Debbie Collier matter. Now, at a press conference last Friday, the police said that Debbie Collier was murdered in a personal and targeted slaying, not a random act of violence. The police also released new video of the 59-year-old showing her sitting for 10 minutes in her rented Chrysler Pacifica outside the Family Dollar store, and it covered the time her daughter received a payment and a chilling message through the payment app Venmo. Now, Collier's cell phone and purse were found where her burned and partially naked body was discovered on September 11th in a deeply wooded ravine near scenic Tallulah Falls, Georgia. Now, they could not confirm that the Venmo message was sent from the device. The police said, "We do not believe that this was a random act of violence. We do not believe that this is an act of a serial killer," according to the Habersham County Chief Deputy Murray Kogod. "We believe that this was a deliberate and personal act." Now, the police also released footage which shows Collier calmly walking into the Family Dollar store in Clayton, Georgia at about 2:55 on Saturday, September 10th, and buying a number of items later found by her body. She's wearing a replica Herschel Walker shirt from his time at the University of Georgia, a blue skirt, and what appears to be black boots with slight heels and a red sun visor. The real estate office manager is then seen at the cash register buying a rain poncho, refillable torch lighter, a 2-roll pack of paper towels, a 7.5 by 9 foot tarp, and a reusable tote bag before leaving at 3:09 p.m. In the new footage, she waits in the black 2022 Pacifica for 10 minutes until 3:19 before heading south on Georgia Highway 15. Now, the Venmo message was received by the daughter of Miss Collier, Amanda Bearden, who's 36, at approximately 3:17. It transferred $2,385 and contained the message, "They are not going to let me go. Love you. There's a key to the house in the blue flower pot by the door." Now, a series of questions for the briefing included the whereabouts of Collier's phone and if it was the device used to send the Venmo message, which the police said they're waiting. And the lead investigator confirmed the phone was found with the body along with Debbie's purse. The police stated they're still waiting for more information to confirm or deny where the Venmo was sent from, but they can confirm that Amanda, the daughter, did receive the Venmo. She received the money, and we don't know where that money is now. Hint, hint, wink, wink, nudge, nudge. Say no more, say no more. Now, police have that cell phone, and they have it in evidence, and it was located at the crime scene, and the police are doing some further investigation. Now, Ms. Collier's cause of death is still not being revealed, and no clues as to any suspects were disclosed. Investigators say they continue to rule out suicide, and it remains a murder investigation. All right, next, Sherri Papini breaks down during questioning on the kidnapping hoax. So the footage shows Sherri Papini speaking to California police after she was found safe and before it was uncovered that her 2016 kidnapping was a hoax. Now, in a video shown on Good Morning America, Papini is heard telling police that she's not sure she wants to speak with them as she doesn't know if they're on her side. Papini, who is filmed with a bandage on her nose, went on to claim that the 2 Latina women held her against her will for 22 days.
The thing I'm scared about, I don't know you guys. I don't know if you're in my corner. I know my husband. I know my husband's in my corner, but, there was a lot of other things.
Now, Papini vanished while out on a jog. She was found hundreds of miles away. Weeks later, she claimed she was branded during her abduction, and she has various bruises, burns, and lacerations, which were later found to be self-inflicted. The Shasta County Police eventually learned Papini was actually with her ex-boyfriend, James Reyes, during those 22 days. Reyes revealed that Papini injured her own nose and that he helped her by shooting a hockey puck off her leg. Papini's husband has filed for divorce in April of this year, 2 days after she pled guilty to lying to the FBI and fabricating her own kidnapping.
It's not an abduction. She asked me to come get her.
No.
I rented a car.
No.
I drove up and picked her up. He passed the polygraph test, Sherri.
If that's not what happened, what did happen, Sherri?
I don't know. No, there's no way it's James. There's no way. There's no way.
The DNA doesn't lie.
Papini was sentenced to 18 months in federal prison in order to pay $300,000 in restitution. The boyfriend had no idea what was going on. What was interesting is that she was able to describe the room, and coincidentally, when she describes the room where she was being kidnapped, it just happened to look like, well, her boyfriend's apartment. Oh, and the boyfriend's cousin also saw her there at the time and was going to say that she wasn't being held against her will. Now, when you look at the actual interview where she is interviewed at the police station when they confront her with her lies. She basically says this all started because she started talking to other guys. That's where all her troubles began. But it's interesting when they confront her with everything, basically saying that her boyfriend has said, none of this is true. He's passed the polygraph test. And she just crumbles and cries and says, no, it isn't so. Liar, liar, pants on fire. All right, the three-ring circus has begun. The Darrel Brooks trial began this morning with jury selection. 4 weeks have been set aside for the trial. Mr. Brooks faces 77 charges for allegedly killing 6 people and injuring more than 60 others after driving his SUV through the Waukesha Christmas parade back in November of 2021. Now, he originally pled not guilty to those charges in February. Then in June of this year, Brooks changed that plea to not guilty by reason of mental disease and defect. The plea was then changed for a third time in September, with Mr. Brooks withdrawing his not guilty by insanity plea. Now, in August, public defenders sought to have the case against Mr. Brooks dismissed in the Waukesha County Circuit Court altogether, claiming that the July 1 search of his jail cell violated Brooks' attorney-client privilege. But the judge handling the case rejected the motion and refused to dismiss the case. Well, now, just recently as last week, Mr. Brooks wanted to represent himself, and guess what? He is getting his wish, and it's not going so great. The judge granted his request last Wednesday, dismissing his public defenders on the case, but the judge said, we're going to trial. We're going to trial. The judge found him to be mentally competent despite suffering from a personality disorder. Well, how have things gone so far today? Well, disrupting the judge. The judge has removed him to another room, and basically he cannot remain silent while the judge is trying to do her introductory remarks to potential jurors in this particular case. The DA has even suggested that you should rely upon some Supreme Court rulings that say that he basically should be gagged. You see, a defendant has a right to be present at all stages of any critical proceedings. Well, clearly trial is a critical proceeding, particularly if you are representing yourself. But you don't have a right to disrupt the proceedings in such a way that basically you're not going to allow a trial to get done. So this is going to get interesting. We're only day 1 into it, and we will see how that turns out. Next, who do you have coming to your house to do handiwork? A serial killer? Well, a suspected serial killer returns to court this Monday in Texas to face a jury for the second time in regards to the 2018 murder of 88-year-old Mary Brooks. Now, the jury deadlocked last November at the first trial, but Billy Chemamir has already been convicted of capital murder in the death of another elderly woman, 81-year-old Lou T. Harris. He was sentenced to life in prison without parole in April and faces the same punishment if he's convicted on Brooks' death. Now, Chemamir is charged with killing 22 women roughly between 2016 and his arrest in 2018. And the charges are mounting as police look at unsolved cases that fit the pattern. Older people whose deaths have been considered natural, often accompanied by missing jewelry or other items that are gone. 4 new indictments were handed down this summer, and prosecutor says Chemamir often posed as a maintenance worker to gain access to the home, and many of the attacks took place at senior living facilities. But one of his victims in March of 2018 survived. Mary Annis Bartol, 91 at the time, told investigators a man had forced his way into her apartment, tried to smother her with a pillow, and stole her jewelry. When police found Chemamir the next day, they also found the items that led them to Harris's home, where they found her dead in the bedroom with lipstick on her pillow. Bartle, who died in 2020, described the attack in a taped interview that has been played at Chemamir's previous trials. Now, Brooks was found dead 2 months before Chemamir was arrested. Her family didn't believe that she died of natural causes, according to her grandson. And her grandson had testified that although she used a cane occasionally, she was healthy and active. He described that she would walk to church, she would walk to the dentist down the street. It's unclear when or if any of the remaining 20 murder cases pending against Chemamir will go to trial. Regardless of whether they do, the district attorney said this guy is going to die in the penitentiary. Now, obviously, Mr. Chandler has pled not guilty, and we'll give him that presumption of innocence until and if he pleads guilty or is found guilty by a jury of his peers. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. If that doesn't want to make you sign up for crimetalksearch.com, this May, more dating malpractice. A couple has been arrested for robbing a man at gunpoint after setting up a fake date on Tinder. Jose Sandoval Jaquez and Crystal Halsey stole a total of $3,000 from the unnamed victim when they met him at the Embassy Suites Hotel in Phoenix. The pair pulled a gray pistol on him and forced him to drive to the nearby Chase ATM and take out $900 before making off with the loot. They also forced him to hand over his phone, ID, cards, social media accounts, and bank information, with $3,000 being taken overall. Now, Jaquez and Halsey were finally brought to justice following a dramatic police chase after cops spotted them on an online advertisement for an escort service. The old set up a date and rob them. Haven't seen that one done in a while. You need to check out exactly who you are going to go and meet, ladies and gentlemen. And don't meet them at a hotel room. Maybe a nice restaurant where there's lots and lots of people. Something along those lines. And more along the dating malpractice, a 21-year-old man has recently pled guilty to targeting and kidnapping a gay man in 2020 through the dating app Grindr with the intent to kill and dismember him. Now, I'm not going to go into the ultimate facts of this case because, hey, we don't want to get demonetized by Google, but let's just say it sounded like a bloody mess, but the guy survived. I mean, he had the intent to murder and dismember, just saying. And the 18-year-old was found in a bathtub, let's just say some nicks and cuts all over him, and other signs of blunt force trauma. He was in a coma for 3 days and remained in the hospital for nearly a month. The feds have said that Mr. Seneca pled guilty to one count of kidnapping. The maximum sentence for the offense is life in prison, and he could face additional exposure if the court finds that Mr. Seneca intentionally chose the victim due to his perceived gender or sexual orientation. Ladies and gentlemen, dating malpractice, to go anywhere without checking somebody out. Now's the time to go to crimetalksearch.com. You'll be happy you did. Okay, our dumb criminal of the day. Now, this could be just a bizarre situation. It could involve mental health issues. We don't know, okay? So we're not putting this out there for any of those reasons, so save your comments, okay? That showed an unidentified man wearing nothing but a right sock, and that he was sprawled on his back on the ground as the MTA employees tried to restrain him. The man eventually breaks free and begins running errantly across the platform, circling the column, and even doing a freestyle breakdance across the floor as he tries to evade employees as they continue to attempt to corral him. Ultimately, he was in fact corralled. So we don't know if this is an intent to do that. I don't know if it was drug related, mental health, I don't know. But generally, when you take your clothes off in public, I don't know, at the subway station, it's just dumb. Even if you got all those other things going on in your life. So just saying. Anyway, this guy needs mental health. We hope we get it, but still just dumb. And why just leave the one right sock? Doesn't make any sense. All right. I want to thank everybody for watching. I hope you enjoyed the show today. Have a wonderful day, not just a good day, and we will see you tomorrow on Crime Talk.